Jefferson almost was not our third president, coming to the post only after the House of Representatives broke an electoral tie vote in his race with Aaron Burr. Marshall almost was not our fourth Chief Justice, receiving the nomination from President John Adams only after the first choice, John Jay, declined reappointment to the Supreme Court. But once fate brought them to their respective positions of authority, Jefferson and Marshall came to blows in ways that put even today's climate of political acrimony to shame. Early in his administration, Jefferson tried to have John Marshall impeached. He accused him of irregular and censurable behavior. In Marshall's hands, Jefferson said, the law is nothing more than an ambiguous text to be explained by his sophistry into any meaning which may subserve his personal malice. He spoke vehemently of his bitter disappointment in his own appointees to the Supreme Court, calling them lazy and weak for not standing up against the crafty Chief Judge Marshall. And Marshall, in turn, labeled Jefferson totally unfit for the presidency. Jefferson called the Chief Justice a man of lax lounging manners and a profound hypocrisy. Now, over time, these two actors played out a rather hateful drama, rooted in personal animus and fundamental disagreement as to the proper role of government and the appropriate balance between judicial and legislative branches. History teaches us that it was Marshall's decision in Marbury versus Madison, a case that many say might as well have been captioned Marshall versus Jefferson, that permanently legitimated and strengthened the Supreme Court, and that gave the Chief Justice his least obvious but perhaps greatest victory over President Jefferson. In the watershed 1800 election, Marshall's Federalist Party lost control of the executive and legislative branches to Jefferson's Republicans. And in an effort to retain some presence in government, Adams decided to pack the judiciary on the way out the door. President Adams appointed Marshall, who was then Secretary of State, as Chief Justice, and Congress passed a number of pieces of legislation to restructure the court system and provide the lame duck Senate and the outgoing president with lots of new judicial positions to fill. Adams filled them, or thought he did, through a series of midnight appointments. But Jefferson fought back. When he took office, he refused to deliver the commissions of some of those appointees. When Mr. Marbury, an appointed judge who did not get his commission, tried to get a court order compelling the administration to deliver it, the case made its way to the Supreme Court. Chief Justice Marshall, to the surprise of many, denied the order that would have forced his nemesis to issue the judicial commissions. But the victory that he handed to Jefferson came with a silver lining to himself. The order was denied on the grounds that the part of the Judiciary Act that had given the Supreme Court the power to issue such orders was contrary to the Constitution. Writing for a unanimous court, Marshall declared that courts, as well as other departments, are bound by the Constitution, and more importantly, that it is emphatically the province and duty of the judicial department to say what the Constitution means. In one fell swoop, Marshall gave up a small power that Congress had conferred on the court and took in exchange a larger overarching power to examine the ultimate constitutionality of all acts of Congress challenged in court. Despite the vehement disagreement of his cousin Thomas Jefferson, this bold assertion by John Marshall has survived as the official answer to this day. The lessons to be learned from the story of Jefferson and Marshall are too many to recount tonight. It's the story of a government that develops and grows and changes over time. It's the story of large institutions competing and accommodating in ways that both amaze and alarm us. Perhaps even more significantly, it's a story that begins a distinctively human thread that we will see woven throughout all of the historic episodes I will mention tonight. The judiciary and the presidency are inhabited by real people with real emotions, real foibles, and a very real, if sometimes conflicting, commitment to do what is right. A second historic moment of interaction between the presidency and the judiciary stars President Abraham Lincoln and Chief Justice Roger Taney. To my knowledge, it represents one of only 2 times that a sitting president has deliberately defied a direct Supreme Court order. In the early days of the Civil War, the fragile American nation faced serious threats from within. The southern states had broken away. European powers were poised to intervene and to divide our young nation permanently. And the war posed another sort of danger, a danger less obvious maybe than columns of soldiers marching through the countryside, but more insidious to a nation conceived in liberty. It was the danger that a government at war might use its extraordinary powers to stamp out political opposition. In April 1861, a trainload of Union soldiers passed through Baltimore en route to Washington, D.C. They were summoned to man the defensive fortifications around the Capitol. They were greeted by an angry mob of Southern sympathizers in Baltimore, and they had to fight their way across that city to another train station where their train to Washington, D.C. waited. Later that night, local authorities who favored the South burned some of the bridges between the 2 cities. They cut telegraph lines between Baltimore and Washington, claiming that Union soldiers might come back looking for revenge. Congress was out of session, and President Lincoln found himself in a capital city with a rebel army to the south and a secession-minded mob to the north. Invoking his power as commander-in-chief, he authorized local military leaders to suspend the writ of habeas corpus along the railroad line from Washington, D.C. to Philadelphia. Essentially, this meant that the Army could arrest civilians without getting a warrant from a court or without probable cause to believe a crime had been committed by the person arrested, and without providing the speedy jury trial that the Constitution guarantees.